this is Alet Ace. I'm a practicing attorney in Pretoria, South Africa, and this is the third episode of Lunch Hour Law. Today I would like to speak about no-win, no-fee agreements. This is something I get a lot of questions and inquiries about. A lot of clients feel they have excellent claims and therefore they would like for me to take on cases on a no-win, no-fee basis, which basically means exactly what it says. Should we not win, I do not take any form of a legal fee. There's a lot to be said about that no-win, no-fee basis. Firstly, the Contingency Fee Act of 1997 is a particular act that regulates no-win, no-fee basis contracts. You cannot do whatever you like. For example, a normal fee has to be described in this contract. So let's say my normal fee for purposes of this episode would be 1,000 Rand. So I need to specify in this fee contract that my normal fee that I usually work out is 1,000 Rand. If we succeed partially, and we need to define that, then I, for example, take 1.5 times what I would usually take per hour. So I would then increase my fee from 1,000 Rand per hour to 1,500 Rand per hour. Let's say partial success for purposes of this exercise is a client would like to claim for medical negligence in the amount of 5 million Rand. If we either settle or at a trial receive an award that's, let's say, 50% of that, so it's 2.5 million Rand of the claim. We either settle for that or we go on trial and we get 2.5 million Rand for the client. That would be, for instances of this example, partial success. So I can either then increase my hourly tariff or my normal tariff from 1,000 to 1,500 Rand, or 25% of the capital amount, which would be 2.5 million Rand. Whichever of the two is less. So the Contingency Fee Agreement Act specifically says your attorney is never allowed to more than 25% of the capital amount. And they particularly brought this act in 1997 because a lot of the, particularly road accident fund attorneys, took a lot more than 25% of claims in the end. The idea of a no-win, no-fee agreement between client and attorney is that both invest equally in this case. I have personally done quite a few of these. It's not only a theoretical exercise, and I've in 2 instances eventually gone on trial. One was a labor matter, the other one was a dog bite matter. Both of them took more than 4 years from the first consultation until we sat in court for the 4 and 5 day trial. So it was very much an investment from my side. I basically worked for free from the first consultation until the end of the trial. By the way, I did not end up taking double my fees because it was not only a partial success, it was a full success in both cases. So that would be double my normal fee or 25%, whichever is less. I did not end up taking that. I probably took a lot less in the end than what would have been my normal fee. And the reason I'm particularly saying this is you would like, in the end, to entrust an attorney with your matter that's not interested in making money from it, that's interested in getting you justice and being compensated fairly. So in both instances, I ended up making a lot less than what I would have had I just done it at my normal tariff, and I waited more than 4 years, right? You are never, ever, ever allowed to do a no-win, no-fee contract with an attorney for criminal matters or for family law matters. These type of fee agreements are particularly earmarked and meant for claims sounding in money. So you would like to typically, where there's money involved, breach of contract, medical negligence, dog bite matters, labor disputes, etc. Claims that you can easily quantify in terms of monetary terms. These are the types of claims that you would like to enter into your lawyer with for a no-win, no-fee basis. If an attorney tells you that they can take a family law matter like a divorce, maintenance claim, protection from harassment act claim, etc., or your criminal law matter on a no-win, no-fee basis, you are entering into an unlawful agreement, which is in of itself a criminal offense. So please do not fall into the trap of trusting anyone that tells you you can enter into a no-win, no-fee agreement on those particular terms for those particular types of matters. Right. Just a few notes that I think I should mention just to end off this very short episode on no-win, no-fee basis agreement. Premature termination. Let's say you enter into no-win, no-fee contract with your attorney. There's a breach of trust, you have a fallout, whatever the case may be, you don't want to proceed with them any longer. That usually automatically triggers them being allowed to tax their entire invoice or all their items of either expenses or legal costs in an account and have you held accountable for that. So the fact that you do not want to proceed with these services does not mean you can walk away scot-free. If you do not want to go until the end, whether it's settlement or a trial, for example, you have to still pay them for all the time up to that stage. So it really is a basis of trust more than any other type of contract with an attorney, I would say. I've already said it's either twice the normal fee or 25% of the capital amount, whichever is less. And there's quite a stringent and lengthy legal taxation process which usually takes place after the entire matter is finalized to make sure what that double normal fee or 25% would be. So there's quite a lengthy cost consultant phase which usually is right at the end. I've mentioned the family law and the criminal law, that's illegal for no-win, no-fee. And also very important, a fee agreement that is entered into no-win, no-fee basis must be done based on a merit assessment. I once, in 2020, I can't remember the exact date, saw an episode of Carte Blanche where they shed some light on labor consultancy firms that entered into no-win, no-fee basis contracts with clients based on a quick telephone call and a one-pager, and that would then apparently constitute the entire fee agreement. That can never be the case. You have to have a proper in-depth consultation with an attorney for that attorney to assess the merits of your claim before that attorney can, in writing, in the fee agreement, say they have assessed the merits and they regard the merits as sufficiently high enough for them to enter into this fee agreement. It's expressly stated that they agree that the merits are very good. So they cannot say that if they have not consulted with you. So please, you cannot on the strength of a short 5-minute call with an attorney or a so-called consultancy labor firm or whatever they may call themselves enter into a no-win, no-fee basis. There will be a snag that does not sound right. It's not reasonable. That is, in a very short nutshell, no-win, no-fee agreements. Again, enter into it with someone you trust. It's based on trust more than any other type of legal mandate, I would say. It's a possibly 3, 4, 5 year journey. You're going to walk with your attorney. Every letter, every pleading, every notice will be done on the basis that the attorney will give it there, all even though they're not paid throughout. For this and similar types of episodes, please subscribe to this YouTube channel, Lunch Hour Law. It's supposed to be a very concise episode and podcast format that can be listened to or watched during your lunch hour. Have a lovely weekend. It's nice and hot. It's spring, and I hope you guys are all keeping well and keeping healthy. And thank you so much.